How insurance affects the defamation trial between Johnny Depp and Amber Heard. The 10th of February 2023. In the summer of 2022, Johnny Depp sued his ex-wife, Amber Heard, for defamation based on an article she wrote about her experience with sexual violence that was published in the Washington Post. The case was resolved in June 2022. The jury found in favor of Depp, and Heard was ordered to pay $8.3 million. Surprisingly, Heard then turned to her insurance company to pay the judgment, according to some. This is because defamation was covered by Heard's liability insurance. This is not an uncommon occurrence. Many homeowners' insurance policies include liability coverage for what is known as personal injury. Personal injury coverage can protect an insured against a wide range of torts and offenses. Libel, slander, or defamation of character is frequently included among the protections provided by personal injury coverage. However, just because an insurance policy covers defamation in addition to bodily injury and property damage does not mean that coverage is always available when an insured is sued for defamation. The specific nature of the defamation, the specific language of the policy, and how a court interprets that language under applicable law will determine whether defamation is covered. Some homeowner policies, for example, only cover defamation caused by an accident. However, defamatory statements are usually made on purpose. A defamation plaintiff must usually show a false statement purporting to be fact. It was published or communicated to a third person, it was done with legally sufficient fault, and it caused damage or harm to one's reputation. To determine coverage, courts in various states have had to closely scrutinize both the policy language and the circumstances surrounding the alleged defamatory statements. In Stellar v. State Farm General Inns, Co., a California appellate court examined a policy that covered defamation arising from an accident in 2007. In the underlying defamation lawsuit, the plaintiff claimed that his brother falsely reported the plaintiff to Child Protective Services for sexually molestation of his 8-year-old son, sent emails to people claiming that the plaintiff was on drugs and had a gambling problem, and published posts on the internet referring to the plaintiff as a pedophile. Because the complaint alleged that the conduct was willful and intentional and arose from an evil improper motive, the court ruled that no coverage was available. However, this does not preclude defamation coverage from being available. California courts have also acknowledged that defamation can be negligent. In Urich v. State Farm Fire and Casualty Co., a California appellate court stated in 2003 that an insured could be liable for defamation for negligently publishing a false defamatory statement. Other states take approaches similar to California's. In Iafallo v. Nationwide Mutt Fire Inns, Co., for example, a New York appellate division court stated in 2002 that defamation does not occur by accident, and thus does not fall within the coverage of the policy, which only covered liability arising from an accident. Similarly, Texas and Florida courts have determined that personal injury coverage for defamation is not available if the allegedly defamatory statements were made voluntarily and intentionally, rather than inadvertently or accidentally. With this in mind, you may be wondering how you can accidentally defame someone. In Grange Inns, Assen v. Lintott, a California district court discussed one of the few cases of accidental defamation. The court used the factual background of Heller v. Bianco, a 1952 California appellate case, to provide an example of accidental publication. In Heller, a woman sued tavern owners, claiming that libelous statements written about her on a wall in the men's restroom defamed her. The owners of the tavern failed to remove the libelous statements after the woman alerted them to them. The woman claimed that the tavern's owners should be held accountable for their inadvertent failure to remove the libelous statements. The court decided that a jury would have to decide whether or not the tavern owners were negligent. However, because the tavern owners' liability for the defamatory statements was based solely on their alleged negligence, the Grange Inns Assen court reasoned that Heller demonstrates that defamation can be an accident where the publication of the statement, rather than its falsity, is the cause. Put another way, the court determined that negligently failing to remove defamatory words from a bathroom stall may be accidental. An older interesting Kentucky appellate case is Allen v. Wortham, where an allegedly defamatory statement was sent to a husband and wife, but unexpectedly published because the couple was illiterate and had to have others read the letter to them. While many courts have focused on whether defamation is an accident to determine whether coverage is available, coverage could still be available for defamation if the policy does not require an accident to trigger coverage for defamation. Commercial general liability policies, for example, typically cover the offense of defamation without requiring an accident. Making a publication with knowledge of its falsity is, however, excluded. Coverage for defamation could also be limited by the application of state laws. For example, in California, California Insurance Code Section 533 says that an insurance company cannot indemnify damages caused by an insured's willful conduct. It appears that Amber Heard's insurance company feels that coverage is not available for the judgment entered against her in part because of this insurance code section. Heard's insurance company has filed a declaratory relief lawsuit alleging that it has no duty to indemnify Heard because her defamatory conduct was allegedly willful, which cannot be indemnified under the California Insurance Code. The insurance company's argument seems to be premised on the heightened standard for defamation, which applies when the person who was allegedly defamed is a celebrity or politician. Generally, a statement made about a public figure requires proof of actual malice, meaning the statement must have been made with knowledge that it was false or with reckless disregard of whether the statement was false or not. According to the declaratory relief complaint against Heard, in the Depp v. Heard case, this heightened standard was applied. The jury determined that Heard's statements were with actual malice and awarded punitive damages. It remains to be seen how Heard's coverage dispute with her insurance company will be resolved. Defamation coverage is highly dependent on the facts of the case, the policy language at issue, and applicable laws. Before you hit send on an angry reply all email or post that clever but derogatory social media post, take a moment to review your liability insurance. Aaron Mindoro Ezra is a regular contributor to Reuters Legal News and Westlaw Today's insurance coverage columns.